Senator Cruz, as I listened to your remarks, I'm reminded of many events throughout our nation's history. It's a storied history involving a lot of comebacks, a lot of instances in which the American people were up against a brick wall of sorts, in which a small group of Americans, often not just a minority, but sometimes a minority within a minority, faced a substantial obstacle. At the founding of our republic, at the moment of our independence, this involved a battle against what was then the world's greatest superpower. Even within our own continent, we didn't have unanimous support. Even among our own people, at times it was a minority within a minority who believed that the cause of independence was worthwhile, that it was worthy of the great effort that declaring independence and fighting a war for it would inevitably require. And yet we persevered, we rallied together as a people, believing fundamentally that our cause was just, and it worked. We've followed that formula many times when it's mattered, and we haven't backed away from fights when those fights were necessary. This may be one of those moments where even though those who are willing to fight against this law, those who are willing to take this effort, are not in the majority. We're in the minority. In this case, in a sense, we're a minority within the minority. It's still worth fighting. I want to commend my colleague, the junior senator from Texas, for his dedication, his commitment, his leadership on this issue. Senator Cruz has never shrunk from this. He has been willing to fight hard for it. He's been willing to speak his mind, even at moments when it was difficult, even at moments when many were suggesting that it couldn't be done or shouldn't be done. And you know, it reminds me of other examples that we've seen over the years of senators who were willing to speak at great length. I see our pages who are here tonight, our pages who serve us well and who are willing to stay late at night working hard. And I'm reminded that 27 years ago, I was a page, much like these who are serving us here today. And I remember a young senator then in his first term. His name was Harry Reid. I remember watching him speak at great length for 10, 12, I don't know, maybe 13 hours at a time. I'm not certain what the issue was at the time, but I know it was important to him. I know that it was an issue on which he was somewhat outnumbered. I know that I saw his colleagues approaching him. Some of them were quite critical of the effort in which he was engaged. And yet, he stood by his message. He didn't shrink from it because he had an inner commitment to the people he represented. And I respected that about him. I could tell he had that kind of tenacity. I watched, as I was a Republican page at the time, I watched my Democratic page colleagues, I watched as they brought him a lot of water, hoping perhaps that eventually he would drink enough water that he would decide that it was no longer in his best interest to continue speaking on the floor. And yet somehow he managed to stay speaking for, I don't know, 10, 12, 13, 14 hours at a time. And I have a great deal of respect for what he did at that moment. And I hope that there's some aspect of Senator Reid that is able to sympathize with what Senator Cruz is going through, that's able to respect the great level of commitment that it takes to stand here hour after hour and engage in this discussion, a discussion that's important for the American people to have. Now, we all continue to hear from our constituents about some of the things that Obamacare might do, some of the things that Obamacare might do to the people rather than for them. I received this one from James in Utah. James writes, "Sir, as a retired U.S. Marine Corps gunny, I would like to express my view and ask that you vote to defund Obamacare. I'm part of the security team here at," and I've deleted the name of his employer, "and our new contract has a massive increase in the cost for health coverage. I fought for the people of this country. Now I ask the same from you. Please help us." Gunnery Sergeant Charlie Jones, U.S. Marine Corps, retired, from Utah. Then I hear comments like this from constituent after constituent, from people who will write in from throughout my state and from throughout the country. Stephen from Minnesota writes, "Dear Senator Lee, please do all you can to stop the implementation of Obamacare. My work insurance went up 8.1% in January in anticipation of Obamacare. I make about $40,000 a year. We do not have any extra money after bills. I would like to see health care available to everyone. We've gone without health care insurance at times, but I believe that Obamacare is not the solution and will result in poorer quality health care overall and hurt our economy. Thank you for considering a Minnesota resident's concerns." Stephen, I'm happy to consider your concerns, and I'm happy to share those with my constituents. This next one comes from Kevin, who's from Massachusetts. He writes, "Dear Senator, I strongly urge you to approve and vote yes on the House resolution bill passed by the House and is now before the Senate that fully funds the government and protects the full credit of the United States, but defunds the Affordable Care Act as provided for in the bill and continuing resolution sponsored by Congressman Graves. It is unfair to exempt everyone with political connections from Obamacare and not to exempt the rest of us. You must understand that Obamacare is undermining American workers and selling out hard for union benefits. It is not fair for businesses to reduce workers' hours to survive. It is time to defund the Affordable Care Act until such time when it can be repealed and things can be straightened out and workers protected. I urge you, please, to delay funding for Obamacare now." That's Kevin from Massachusetts. When we look at these examples and we read other similar examples like them, from people writing from throughout my state in Utah, and people writing from throughout the country, we see a consistent pattern. Americans are justifiably, understandably fearful of losing their jobs, of having their wages cut, of having their hours cut, in some instances losing access to health care, sometimes to a health plan upon which they and their families have relied for many years. This is a difficult situation for them because health care is an especially unusually personal thing. Access to health care is something that people don't necessarily want to entrust entirely to their government. And yet that seems to be the direction in which Obamacare inevitably takes us. It puts more and more of our health care into the control of the federal government. And as has been suggested on the floor tonight, as some of my colleagues, some of my Democratic colleagues from within the Senate have acknowledged, this is but a step in the direction of what they hope will be a single-payer, government-funded, government-run health care system, funded, operated, administered entirely from Washington, D.C. Now, there are some things that government can do, in the sense that there are some things that government is rather uniquely empowered to do. Providing, for example, for our national defense. And that's something that we do from Washington. That's a power that's entrusted to us by Article 1, Section 8 of the Constitution. With roughly 1/3 of the provisions of Article 1, Section 8 being dedicated in one way or another to our national defense. That's something that Washington can do. It's something that Washington must do, and that Washington is rather uniquely empowered to do under our constitutional system. Healthcare is, of course, important, undeniably important. In many respects, it's as important as national defense. The fact that it's important doesn't necessarily make it a responsibility of the federal government, nor does it necessarily qualify the federal government as a practical matter, setting aside the constitutional question. It doesn't necessarily qualify the federal government as an effective health care provider. Many people fear the day when our federal government becomes much more empowered over the very personal decisions of our lives, particularly those affecting our access to health care. Many people are also suspect of the new taxes imposed by this law, the new permutations that this law will introduce into the lives of the American people. We've discussed several times today the manner in which this law was enacted, the manner in which it was introduced as a bill, brought to the floor of the House of Representatives after then Speaker of the House, Nancy Pelosi, informed her members that they needed to pass the bill and then they could find out what's in it. One of the things that we have not discussed as much is the fact that even after that was passed, without members of Congress having adequate opportunity to review this legislation, even after that happened, and setting aside the 20,000 pages of regulations that have been added to this corpus of federal law up until this point, we've had two significant revisions of the law, revisions that were brought about not legislatively, but by the judicial branch of government. Revisions that the judicial branch of government had no authority to impose. I'd like to talk to you about both of those. When the Affordable Care Act was challenged as to its constitutionality, there were two primary constitutional challenges brought to the attention of the federal court system that ultimately made their way to the Supreme Court of the United States. One of those challenges involved a constitutional attack on Congress's authority to enact the individual mandate, the provision compelling individuals to buy health insurance, not just any health insurance, but that kind of health insurance that the federal government, in its infinite wisdom, deemed appropriate and necessary and essential, indispensable to every American, everywhere. The argument presented in those constitutional challenges, culminating at the Supreme Court of the United States, was that Congress had acted pursuant to its authority under the Commerce Clause, Article 1, Section 8, Clause 3 of the Constitution, which empowers Congress to regulate commerce among the several states, with the Indian tribes and with foreign nations. The argument said Congress does have power to regulate interstate commerce, and the Supreme Court has interpreted that power rather broadly since 1937. And yet, even under that extraordinarily broad interpretation of the Commerce Clause, so the argument went, Congress doesn't have the power to regulate inactivity. The failure to purchase health insurance is not an interstate commercial transaction. In fact, it's not a transaction at all. It's a failure to act. The Supreme Court of the United States accepted that argument and concluded that even under the extraordinarily broad, deferential standard of review used by the Supreme Court since 1937, this could not pass muster as a valid, legitimate exercise of Congress's Commerce Clause authority. The Supreme Court justices rejected that argument by a vote of 5-4. Oddly, however, the Supreme Court went on to conclude that the individual mandate was nevertheless constitutional, not under the commerce power, but under Congress's power to tax. In essence, what you had was 5 justices of the Supreme Court, led by the Chief Justice of the United States, the Honorable John Roberts, who as I see it, effectively rewrote the individual mandate provision as a tax, saved it only by recasting it as a tax or as a valid exercise of Congress's power to impose taxes. There are a couple of problems with that interpretation. First and foremost, Congress could have adopted a tax, could have imposed a tax as an enforcement mechanism to bring about compliance with the individual mandate provision. And yet, it decidedly did not. It used language that, under at least a century's worth of jurisprudence, was clearly, unequivocally, a penalty and not a tax. You see, there's a long line of cases that helps courts decide whether something is, on the one hand, a penalty or, on the other hand, a tax. And this was, under a century or more worth of jurisprudence, a penalty and not a tax. It's also important to note that the House of Representatives initially considered language that would have attempted to enforce compliance with the individual mandate provision by means of a tax, using language that under a century's worth of jurisprudence would have been regarded as a tax. Yet interestingly enough, and not surprisingly, that language was rejected. That proposal did not carry the day. That proposal could not carry the day. Why? Well, because most Americans understandably are reluctant to raise taxes on middle-class Americans. It was soundly rejected. It could not carry enough votes, even in the Congress in place during the first 2 years of President Obama's administration, a Congress that was overwhelmingly Democratic in both the House of Representatives and in the Senate. It could not carry the day. So the Constitution requires that revenue bills originate in the House of Representatives. If this was a new tax, it would have had to have originated in the House. In a sense, in a very significant sense, one could argue, the bill that ultimately became the Affordable Care Act, Obamacare, did originate in the House. It came over here to the Senate. It had its provisions stripped out and replaced by Senate language, but many people still consider that a House bill. The problem here has a lot to do with the fact that the tax language did not originate in the House or in the Senate. It originated instead across the street. It originated instead across the street with 5 lawyers wearing black robes, who we call justices. Now, those 5 lawyers wearing black robes, who we call justices, are no more empowered than the Queen of England to impose a tax on the American people. And yet they imposed a tax on the American people. This is not okay. This is not acceptable. This was a lawless act. This is something that we should be ashamed of as Americans. This was a sad, shameful moment when the Supreme Court of the United States took upon itself the mantle of a super legislative body, which it is not. Unable to bring about a massive tax increase on the middle class, the Congress adopted what it could. What it did adopt, the Supreme Court found to be unconstitutional on its own terms as it was written. The Supreme Court, apparently unwilling to do its job, and all too eager to do the job of the legislative branch, rather than acknowledging the unconstitutionality of that provision, simply resurrected it by rewriting it as something that it is not, was not, and never could be. Interestingly, this was not the only insult to the Constitution in connection with that case. You see, in the same dispute in which the Supreme Court rewrote Obamacare in order to save it, in the same case in which the Supreme Court of the United States rewrote the individual mandate provision as a tax when in fact it was a penalty, they did something else. You see, a separate majority, an even larger majority, a 7-2 majority, concluded that another aspect of the Affordable Care Act as written could not withstand constitutional muster. You see, the Medicaid expansion provisions left the states with no option, no alternative, no choice other than to accept a significantly expanded Medicaid program, a program that's administered by the states, that's partially funded by the federal government, but ultimately administered by the states. The Supreme Court of the United States, citing long-standing precedent, said this is not okay. You see, Congress doesn't have the power to commandeer the state's legislative and administrative machinery for the purpose of implementing a federal policy. Congress may not do that. It's not within our power. And yet, a large majority of the Supreme Court concluded that's exactly what Congress did in the Affordable Care Act. So faced with yet another constitutional problem, the Supreme Court adopted yet another rewrite that the Supreme Court of the United States was not constitutionally empowered to bring about. What the Supreme Court did in that circumstance was to just read in or write in an opt-out for the states so as to make it constitutional. Now, some have tried to defend this by saying, well, that's what courts do. When courts find that something's unconstitutional, they have to look a second time to see whether they can read into it a different interpretation that might be fairly possible, a fairly plausible interpretation that could allow them to save it. But here, there was nothing there. There was nothing that could allow them to do this. The court's job at that moment was to figure out whether or not the unconstitutional provision could be severed from the rest of the statute, whether it could be excised out, sort of like a cancerous tumor, allowing the healthy tissue to remain with the cancerous tissue gone forever. There are rules, there are standards that the Supreme Court is supposed to follow when engaging in this exercise. And whenever it does this, it follows decades-old severability jurisprudence. Well, that standard, I believe, if followed, would inevitably have culminated in the Supreme Court of the United States finding that the Medicaid expansion provisions could not be severed from the rest of the statute, the other provisions in the Affordable Care Act. And I suspect that may well be why the Supreme Court did not engage in severability analysis. It instead rewrote the law. So the Supreme Court of the United States rewrote Obamacare, not just once, but twice in order to save it. This is not okay. This is not constitutional. This is not American. Now, the next response that defenders of this law usually bring up is, well, it is, after all, the Supreme Court's job to decide what's constitutional and what isn't constitutional. So if they say it's constitutional, then it must be constitutional. And who is anyone else to second-guess their judgment as to constitutionality? Okay, well, I understand that argument. That argument is fine, perhaps as far as it goes. You can't read too much into that statement. It's not fair to say that the Supreme Court is the sole expositor of constitutional meaning. It is true, of course, that within our federal system, the Supreme Court has the last word in deciding questions of federal statutory and constitutional interpretation for the purpose of deciding discrete cases and controversies properly before the court's jurisdiction. That, however, does not excuse the rest of us from independently exercising our own judgment. Nor is it the case that every constitutional infraction, every constitutional indiscretion is necessarily within the competence of the federal courts to resolve. In fact, there are countless circumstances in which, either because the court might lack jurisdiction or because no plaintiff can be brought forward with Article III standing necessary to challenge the federal action in question, or because the courts have recognized that there is a non-justiciable political question at stake, for whatever reason, the courts in a number of circumstances might not be competent to address a particular issue. In other circumstances, a case, for whatever reason, simply is not brought. In many, many circumstances, the courts don't have occasion to address a constitutional infraction. But regardless, we are never excused. We, as senators of the United States, having taken an oath under Article 6 of the Constitution to uphold the Constitution of the United States, we're never excused from our responsibility to look out for and protect and defend the Constitution of the United States. And when we see an unconstitutional action, we need to call it out as such. And we need to do whatever we can to stop the Constitution from being violated. The Constitution was violated, the Constitution was distorted, the Constitution was manipulated. It was defiled, not once but twice, by the Supreme Court of the United States when the court rewrote the Obamacare Act, the Affordable Care Act, twice in this decision that was rendered at the end of June 2012. This is one of many reasons why I think it's important for us to have this debate and this discussion about whether we fully fund the implementation and enforcement of this law. A law that was never read by those who enacted it, a law that has become less popular rather than more popular subsequent to its enactment, a law that has now spawned some 20,000 pages and counting of new regulatory text. This same law was rewritten not just once but twice by a Supreme Court of the United States that openly flouted the Constitution of the United States, thumbed its nose at its own constitutional responsibilities. We're now being asked whether we should continue funding the implementation and enforcement of that act, and I think not. In addition to the unconstitutional rewriting by the Supreme Court of the United States, we've now have several instances in which the President of the United States has himself attempted to rewrite the Patient Protection and Affordable Care Act. The President of the United States has said that although enforcement of the employer mandate provision is set to begin on January 1st, 2014, that the President's administration will not implement and enforce that provision effective January 1st, 2014. Although the President lacks any constitutional or statutory authority to make this decision, although the President has neither sought nor obtained a legislative modification from the legislative branch of government, Congress, the President is treating the law as if it contained that modification already. There was another modification that took place with respect to the implementation of the out-of-pocket spending limits, the spending caps. This, too, was done without any legislative or any constitutional authority. And there's another modification that the President made with respect to proof of eligibility for subsidies on the exchange networks set up by the Affordable Care Act. All three of these modifications were made by the President without any statutory authority, and they were therefore extra-constitutional modifications. Now, as I understand it, a few weeks ago when someone asked the President of the United States why this was appropriate, when somebody challenged the President of the United States with regard to his authority on these modifications, his response was something like this. Under ordinary circumstances, under more ideal circumstances, perhaps I might have gone to Congress to get Congress to modify the statutory provisions in question. But these are not ordinary or ideal circumstances. I'm not sure exactly what he meant, but it sounds to me like what he was saying was, I'm in a tough spot, so I've got to do what I can do, what I can get away with, because I've got a Congress that is now less cooperative, less inclined to cooperate with me, less inclined to do what I, as President of the United States, want Congress to do than the Congress that was in place in 2010 when the Patient Protection and Affordable Care Act was enacted into law. Well, that's interesting. It's interesting on a number of levels because, number one of the reasons why that Congress is now less inclined to be cooperative with the president, one of the reasons why the Congress is no longer as inclined to do the president's bidding is, interestingly enough, because of the Patient Protection and Affordable Care Act, because of the widespread public outcry that came from across this country as a direct result of the enactment of this statute. It's not at all unusual to have a divided Congress. It's not at all unusual for one or both houses of Congress to be under the control of a party other than the president's own political party. And yet it has never been the case and can never be the case that there is somehow an exception to the Constitution, that there is somehow an exception to Article I's provision that all legislative powers granted by the Constitution shall be vested in a Congress consisting of a Senate and of a House of Representatives. The fact that the president finds political dissent within the Congress irritating does not make him a king. The fact that Congress won't always do the president's bidding does not vest him with the powers of a despot. And when someone holding the office of President of the United States purports to wield legislative powers, when the President of the United States purports to make law by the stroke of the executive pen, we have exited the territorial confines of constitutional government. These are some of the reasons why we have focused this debate back on Obamacare. People are frequently bringing up the argument, this is law, this is settled law. Because it is settled law, you must fund it. First of all, I am aware of no constitutional command that says that simply because a law has been adopted, Congress must fund any and every provision authorized under that law. In fact, quite to the contrary, because Congress holds the power of the purse, Congress must continue to have the authority to decide what programs to fund and which programs not to fund. Were it otherwise, we would have a really strange set of circumstances in which one Congress could bind another Congress simply by passing a piece of legislation and not by constitutional amendment. That is not the case, never has been the case, never could be, should be, or will be the case under our constitutional system today. And so what we see is the fact that this is not simply a partisan political debate. Many are casting it as that. Many are pointing to the fact that we have some Republicans agreeing with some Democrats, but for the most part, we see widespread disagreement between Republicans and Democrats. But that dramatically oversimplifies the matter. This is no longer simply a dispute between Republicans and Democrats. In many respects, this represents a dispute between the political ruling establishment of Washington, D.C., on the one hand, and the American people on the other hand. You know, one of the things that we're often told that we have to face here is that we have to choose to keep everything funded, or we have to choose to fund nothing. It's a frequent source of frustration to many who serve in this body. It certainly has been a frequent source of frustration to me and to the 3 million people I represent from the state of Utah. It's odd that we find ourselves in a position to vote on a continuing resolution, one that funds everything in government or nothing in government. It's a frustrating exercise that we have to go through. Because of the fact that we've chosen to appropriate this way year after year, we basically have one opportunity to decide what we're going to fund in government and what we're not going to fund in government. I wish that what we could do is, at a minimum, a bare minimum, it should be a lot more than this, but at a bare minimum, to have two different debates, two different discussions, both starting from the presupposition that we fund nothing, but both culminating in funding or not funding something. One that would deal with funding for Obamacare, and another one that would deal with funding for everything else in government. It would be nice if Obamacare funding had to stand or fall on its own merits. If we were starting from zero when it came to providing Obamacare funding, and we had to justify it, we had to make the case for it, we had to say, let's prove to the American people why we ought to be funding the enforcement of this law that will make health care less affordable rather than more. And this law that's being implemented in a fundamentally unfair manner. I think that would produce a very different debate and discussion. But very often the way things work in Washington, the way continuing resolutions work, we're faced with a set of circumstances that don't really accurately reflect the way we make decisions in any other aspect of our lives. I sometimes am inclined to analogize this kind of continuing resolution spending to the following. This is a vast oversimplification, but suppose that you lived in a very rural, remote area. Suppose that the closest town to where you lived was at least 100 miles away, but that there was one market, one grocery store, just a mile from your home. It was the only grocery store within at least 150 miles, let's just say. And one day, your spouse calls you as you're on your way home from work and says, stop at the store, we need bread, milk, and eggs. You go to the grocery store, and you find the bread, you put it in the cart, you find the milk, you find the eggs, you put those things in the cart, you get to the checkout counter. The cashier runs up those things, and then the cashier says, now, wait a second, you can't just buy these things. You cannot just buy bread, milk, and eggs. You say, well, why? Why on earth can I not just buy these three items? This is all I need. Well, this is a different kind of grocery store. This is a grocery store patterned after the United States Congress. And in order to buy bread, milk, and eggs, we're also going to require you to buy a bucket of nails and a half-ton of iron ore. You can use our wheelbarrow to take it out to your car. And a book about cowboy poetry, and a Barry Manilow album. You say, I really don't want any of those things. And the cashier says, well, that's fine. Then you don't get your bread, your milk, and your eggs. At that point, you as the shopper, not wanting to come home to a very disappointed spouse, are likely to say, fine, even though I don't want the nails or the iron ore or the cowboy poetry book, and I definitely don't want the Barry Manilow album, I'm going to buy those things because I can't buy the things I need unless I also buy those things. That's how we spend in the United States Congress. Whether we like it or not, and most of us really, really don't like it, that's what we're stuck with. And so that's one of the reasons why we're having this debate now. One of the reasons why I think it's appropriate for us to have this debate in connection with this. It's unfortunate in many respects that we tie something so fundamental to who we are as a country, something so essential to our ongoing existence as a nation, as national defense. It seems absurd that we should tie that to funding for Obamacare. And yet that's where we find ourselves because of the fact that we've been operating under a continuous string of back-to-back continuing resolutions for the last 4 or 5 years. It's time for us to start breaking away from those false and ultimately ridiculous choices. It's time for us to demand more as a people from our Congress. It's time for us as a people to start to demand independent debate and discussion that far more closely reflects the will of the American people and their ongoing needs. If the United States Senate must choose between, on the one hand, standing with the long-standing interests, the entrenched interests of the political governing class in Washington, on the one hand, or on the other hand, standing with the American people, I hope, I expect that we will stand with the American people. And if you ask any member how constituents are feeling about the Affordable Care Act, how constituents are feeling about Obamacare and its coming implementation and enforcement, the response you will get is that, at best, constituents are mixed. In many cases, they're apprehensive, they're uncertain, but overwhelmingly, you'll find a lot of opposition from people who are seeing those all around them facing job losses, wage cuts, cuts to their hours, and cuts to their health care benefits. How long are we going to have to continue to hear these things before we act? Are we really, as a Congress, willing to just look at these things and say, yeah, well, bad things happen. Let's just allow them to happen? Are we willing to do that? Those who are Democrats, are they willing to do that, saying, yeah, I know this law is not perfect, but it's a speed bump that we've got to cross over on our way to a single-payer system run by the health care system? As Republicans, are we really willing to endure that, saying, yeah, it's a train wreck, but the good news is it might inure to our political benefit if it kicks in? I hope we're not willing to do that. I hope we have not descended to such a shameful, cynical low that we would be willing to allow those political interests to trump the needs of the American people who are calling out, crying out for help and for relief. Ultimately, as we think about our responsibilities as senators, as we think about our responsibilities as citizens, I hope that we will reflect from time to time on the fact that we've all taken an oath to uphold this document, this 226-year-old document, a document that I believe was written by the hands of wise men raised up by their Creator to that very purpose, to help foster and promote what would become, what has become, the greatest civilization the world has ever known. To the extent that we respect and honor this document, to the extent that we follow it, to the extent that we defend it, we uphold it at every turn, to the extent that we consider it not just a responsibility of the judiciary, but also of the political branches of government, including our own branch, we have prospered as a country, and to the extent we will return to those practices, we will benefit directly as a result.